Council and the other organizers of this really interesting conference. It's a pleasure to be here and also to be among such a dynamic group of participants. I look forward to the final 2 days of the LBC. And I'd also like to thank the British Council for honoring me with this invitation to serve as a keynote speaker. It's really somewhat of a homecoming for me. I don't think that anyone at the British Council knew that I had a prior connection to Senegal, but in fact I lived here for 6 years in the 1980s and 1990s. I did doctoral research on the Wolof language and how it was used in an urban setting, being mixed with French. And I think one of the most rewarding experiences of my life has been to learn the Wolof language and to understand the depth of its richness and its expressivity. And I've retained this passion for African languages in particular throughout my professional life, even though through the twists and turns that happen to anyone over a lifetime of work, I ended up going into the field of international justice, even though I began as a linguistic anthropologist. And one of the things that William mentioned, I oversee a program called the Brandeis Institute for International Judges, which is a regular gathering of judges who serve on the benches of international courts and tribunals across the globe. Institutions that have either an international or regional jurisdiction. And this is human rights institutions, courts in Africa, the Americas, or Europe, interstate dispute resolution institutions like the International Tribunal for the Law of the Sea, the International Court of Justice, and of course, international criminal courts and tribunals. And over the years of organizing these institutes for judges, I would hear them talk about their institutions, which are very, very diverse, not only within the institutions themselves, with judges from many different backgrounds, legal as well as linguistic, as well as cultural and national, but also the parties that come before courts are very, very diverse. And I was always asking myself, how does this work from a linguistic point of view? How does linguistic diversity play out within these institutions, and how are they handling the challenges of linguistic diversity? When the International Criminal Court was established in 2002 and began its work, I saw that all the cases that were coming up in the early years involved African situations. And this deepened my interest in how an institution like the International Criminal Court could actually deal with the many languages that were pertinent to it.
Have in the context of a trial, they had been theoretical, and once they were sort of put into practice, they realized we have to come and do another expert panel to get this right. So they're very, very careful about terminology. These are the situation languages as of 2017. They may be hard to see. There are 33 African languages being at play in the work of the court. Over 8 situations in DRC, Uganda, Central African Republic, Sudan, Kenya, Libya, Cote d'Ivoire, and Mali. And more recently, there is a situation in Georgia, and there are 3 languages that have been that are in play for that: Georgian, Ossetian, and Russian. Now, what's interesting is that the court really does not publicize any of this work. This looks like it's off a website, but it's not. It's for a poster that the court created to present at a conference on language interpretation and translation, it's an internal document which they gave me. So nowhere on the website does anyone visiting, wanting to know more about court, actually know that they're working in all these languages. Here's a very interesting terminology bulletin from 2012 that the court put together. This is one page from it. I know that's hard to see. It's called courtroom phraseology. What it is dozens of predictable phrases that are used throughout the many phases of an ICC proceeding, so there's consistency in interpretation. This is from a page on the section called Commencement of Trial. It says, in order to convict the accused, the court must be satisfied of his guilt beyond unreasonable doubt. And let me now turn to the law. And according to the established case law of this court, the victims are entitled to participate in the proceedings. And these phrases are in English, French, Lingala, the Congolese variety of Swahili, Sango, Standard Swahili, and Arabic. This allows interpreters to use the same terms, and so there's consistency over the course of a trial. One of the interesting things about the ICC is that it sort of sets itself off as different from other international criminal tribunals that preceded it, and as such, it's really come up with some of its own terminology in English and French for particular legal terms. And they are not what is normally used. And in particular, French ones have had to follow sort of the English model. So where in French the term for charges would normally be chef d'accusation, it's now les charges, coming from English. The disclosure of evidence is usually in French communication des pièces, and there it's divulgation. And the term indictment from the common law, civil law countries were trying to sort of have more of a presence in the Rome Statute. They got rid of the term indictment altogether, and it's called the document containing the charges and document contenant les charges, which to the French ear sounds kind of ridiculous. But what happens is that anybody working at the court has to learn this language. They have to learn these terms. These are the terms that are used. They cannot be changed, which makes it sort of different from preceding international criminal judgments from other institutions. And I want to call your attention to the logo here of the International Criminal Court. And I have to say that Banda Norain on the right. And let me just talk about two very innovative things. So Dominic Ongwen had a document containing the charges that was more than 100 pages long with 70 charges that was entirely translated into Acholi so he could read it. Legal jargon, yeah, that's not, believe me, I'm trained as an anthropologist and I work in law, and I mean, some of the terminology is really, really dense. I don't think that the ICC is doing anything to try to reduce the jargon. I think that they have created new jargon. But one of the roles of field interpreters is to what they call, what do they call in English? They call it to orient, or to, I guess they call it to orient a witness to the courtroom and to the procedure. So they will, someone who's about to testify, particularly if it's someone who's come from a situation country for the first time, is in a very, very foreign setting, is afraid, is unsure, has to talk about very, very painful things. They take this witness, they take them into the courtroom before the trial, their trial hearing starts, shows them where they'll sit, shows them where the judges are, where the defense is, where the accused person will be, where the prosecution is, where they will have someone by their side if they don't understand a question. Someone will help them with the technology. So there really is a lot done to help people. There's a psychological assessment done of the vulnerability of witnesses. They really do a lot to try to make this a process where a witness feels that they have brought their story to a forum where someone is going to listen and there may be an impact without it being, by minimizing the trauma of it. So I mean, I have been really impressed by the efforts they make to help someone. And if a witness becomes very upset, they shut down the hearing until that person can recover their equanimity. So yes, there's jargon, legal jargon. I don't know. I think lawyers, that's how they're going to maintain their niche. But So I don't think that they were. And Brexit in English. There are, as I said, many, many Anglophones working at the ICC, and there's many Anglophones in all international institutions. And a number of them, there's a real glut, I would say, of Anglo-American legal experts in the Office of the Prosecutor and on the defense teams and in the registry. And I think that's problematic. One of the ideas that I want to pursue in my research is how the dominance of English is narrowing or even shutting down the development of international criminal law, in the sense that people are imprisoned in an English language frame, and it is narrowing their ways of interpreting the law and also the jurisprudence that they can actually reference. So I think it's got some not only practical issues, but it's got some really big conceptual issues that English speakers don't want to hear about. Especially monolingual English speakers, and that would be the Americans, the Brits, the Australians, the South Africans, and there's lots of them. But I have to say that one of the reasons that English is dominant is that Asians don't tend to speak French. The people from the former Soviet Union do not tend to speak French. People from Latin America, they may speak French, but there's a lot of regions in the world where if you have to speak one working language over another, your second language is going to be English and not French. And so that's another way that French is being sort of sidelined, is that it's a reflection of the decreased prominence of the French language, on a global thing. So I don't think the Brits leaving is going to make a big difference, and out of the European Union. And I think there will always be a really big British, let's say an Anglo-American presence at the ICC, because after all, it's that legal system that excels in courtroom practice, unlike in a civil law system where they don't have the same kind of adversarial kind of procedure. It's the barristers, it's the litigators from the United States who are down there on the floor and who are really making things sort of tick, move along in these trials.
Okay, out of respect for the time and for the 5 speakers in the next session, we're going to conclude here. And again, just a reminder that if you want a fuller exploration of these issues, then please go along to the Language and Equitable Access to Justice session at 11:30. Let's have a round of applause, please, for Leigh. And here's Philip.